Commissioner Harmon.
Thank you. By now, all of us should be in possession of the item from Hollow and Hollow Attorneys, which is also in the possession of our law director dealing with the matter of McElroy versus Knox County Commission. It seems to me the relevant paragraph related to us is on page 4, where it says, we propose that in order to remedy this situation, the County Commission, which is still validly in place, the Commission as it existed prior to January 31st, 2007, be reconvened at a public meeting to with adequate public notice, that the mandate of the Supreme Court be once again addressed. I move we add that to our, move that to the full Commission agenda without recommendation.
Okay. Thank you, Commissioner. John, you wanted to talk about this for a moment?
Yes, I do. Just a moment. Here you go. I've prepared some thoughts on this. I want to read those to you as the committee, and I'll read the same thing to the next committee. Basically this, what we're talking about, I believe, is a very serious legal matter. It in fact may be the most important legal matter that I have ever discussed or will ever discuss with this commission. As you know, the Knoxville News-Sentinel has sued the Knox County Commission and the commissioners who voted to make appointments on January 31 under the Open Meetings Act. 12 of you have been served with the lawsuit because 12 of you participated in the January 31 appointment process. I've passed out copies of the lawsuit to those of you who are not parties, and this lawsuit is pending in the Knox County Chancery Court before Chancellor Fansler. We've received a letter from Rick Hollow, the lawyer who represents the plaintiff, Jack McElroy. Mr. Hollow's letter proposes a settlement, and I've passed out copies of that letter to each of you, and that's what Commissioner Harmon was just speaking to. As the attorney for Knox County in this commission, I'm passing out the letter to inform you of the proposed settlement. It is the full Commission's prerogative whether to accept it, reject it, or to instruct me to make a counteroffer. At the full Commission meeting on Monday, February 26, one or more of the Commissioners may make a motion to add this matter to the agenda. If there is opposition to adding it, the agenda is amended and the matter will be discussed. If even one Commissioner objects, it can only be added to the agenda by a 2/3 vote of this Commission to suspend the rules. That's this Commission's rules. Then the Commission may consider this proposal. If the matter is not added to the agenda on the 26th, then any one Commissioner may put it on the agenda for the March meeting. Without talking about the facts of this case, I want to talk about the Open Meetings Act, otherwise known as the Sunshine Law. As you know, the Sunshine Law is a very serious matter. It expresses the public policy of the state of Tennessee that the formation of public policy and decisions is public business and shall not be conducted in secret. The law was first passed in 1974. Tennessee Supreme Court first ruled on this statute in 1976, and since then there have been a number of cases. The Sunshine Law is remedial. This means that the court liberally construes the law in furtherance of its purpose. Violations of the law have certain necessary consequences. The court can put down an injunction against the persons who violated the law. The court can retain jurisdiction over the governmental body for a year and require reports from the body. The most notable consequence, however, is that, and I quote from the law itself, any action taken at a meeting in violation of the Sunshine Law will be void and of no effect. Over the years, the Tennessee Appeals Court has fashioned a remedy or a cure where there has been a violation of the Sunshine Law resulting in a void action. That remedy is known as a redo. What is a redo? It is exactly what it sounds like. The governing body reconvenes, and there is a new and substantial reconsideration of the issues in the presence of the public. And that's what Rick Hollow's letter mostly addresses. You may ask, in our situation, which governing body would reconvene? The one that existed as of 9 a.m. on Wednesday, January 31. There are issues under the Open Meetings Act. Some of those issues include, what is a meeting? Is it a quorum? Does it only take two? And what does it mean to deliberate? I want you to know that this office, my office, which I've been a part since 1990, and at least since 1990, if not before, and supported by a Tennessee Attorney General's opinion in 1988, has always cautiously advised that 2 or more commissioners should not deliberate toward a decision in any matter that can be reasonably foreseen to come before the Commission. The Tennessee Appeals Court has defined what it means to deliberate. To deliberate is to examine and consult in order to form an opinion, to weigh arguments for or against a proposed course of action. That definition comes from Nice v. Paris Special School District, a 1990 Court of Appeals case. Chancellor Fansler, who has both of our lawsuits, I believe, in his court, adopted this definition of deliberation in a case that came before him several years ago. Naturally, these are legal issues that will be addressed if this lawsuit continues. I am not prejudicing or prejudging, certainly, the facts of this case. However, Knox County has an opportunity, as noted through Rick Hollow's letter of settlement, to settle the case now. The settlement proposal has advantages. These are some that I see. It may aid in restoring the public trust that some are quoted as saying is shaken. It does not require the Commission to admit that it violated the law. It is a swift resolution rather than a prolonged litigation. It is less costly than protracted litigation. It allows the Commission to resolve the matter now without having to be told to do so by a court. In the absence of a settlement, the county and the members of the Commission, old and new, face prolonged litigation, including discovery. Discovery means that each member of the old Commission, and probably each new Commissioner, will most likely have to give his or her deposition. The new Sentinel can subpoena cell phone records and electronic communication. Deposition transcripts of elected officials are public record. The depositions themselves may be open to the public. There would probably be an appeal. This matter may still be going on a year from now. While it may be difficult to get our minds around a redo because it means bringing people back, it is not an impossible task. It is easier to do it now than later after the new Commission has been conducting months of business. I will advise you that, in my opinion, any and all acts of officials who were appointed on January 31, 2007 and who have been conducting official county business are, at the very least, de facto officers, and their official acts are de facto legitimate. And I believe we can make that part of the consent decree as well to lay those fears to rest. Also, you will note that the new Sentinel has sued each commissioner individually in both his or her official and individual legal capacities. I've personally spent many hours researching and discussing with my legal staff the issues this presents, including separate legal representation for each individual. Any potential violation of the Act would, in my opinion, of necessity, be made only through a person's official action. Otherwise, there could be no violation of the Act. I've discussed my concerns and my opinion with Mr. Hollow, the new Sentinel attorney, and he agrees that the claims against commissioners in individual legal capacities should be dismissed. As it stands right now, I see no substantial reason why I and my legal staff cannot represent the legal interest of Knox County Commission, of Knox County, and of the commissioners in their official capacities. That should be all that remains in the lawsuit, is the Knox County Commission and commissioners in their official capacities. So if any defendant wishes to hire private legal counsel to either represent them in this matter or to merely provide them with legal advice, they are more than welcome to do so. But that, of course, would be at their expense. So you've got the letter from Rick Hollow, and those of you who aren't involved in that lawsuit now have a copy of the lawsuit if you didn't have it before. But I would ask you to consider the letter from